Hi, my name is Shaye Larkin. I'm a San Francisco bankruptcy and tenant rights attorney, and I help tenants who have been overcharged by the landlord for repairs and cleaning after they've moved out. Often this involves the landlord taking illegal deductions from the security deposit, as well as charging additional amounts that exceed the amount of the security deposit. In the past 2 years, however, I have seen a lot of cases where the tenant did not pay a security deposit at move-in and is now being charged for repairs and cleaning after they've moved out. This video is about the situation where you did not pay a security deposit at move-in and are now facing a big bill from the landlord. This video is based on California law, and watching this video is not a substitute for sitting down with your own attorney and getting specific advice about your specific situation. You may have watched my other videos pertaining to illegal deductions from the security deposit. When no security deposit has been paid, some of the same laws protect tenants from illegal charges for repairs and cleaning after the tenant has moved out. The provisions of California Civil Code Section 1950.5e protect tenants from illegal charges by the landlord regardless of whether or not they paid a security deposit at move-in. Section 1950.5e2a states, "The landlord shall not assert a claim against the tenant or the security for damages to the premises for any defective conditions that pre-existed the tenancy, for ordinary wear and tear or the effects thereof, whether the wear and tear pre-existed the tenancy or occurred during the tenancy, or for the cumulative effects of ordinary wear and tear occurring during any one or more tenancies." Section 1950.5e2b states, "Claims against the tenant or the security for materials or supplies and for work performed by a contractor, the landlord, or the landlord's employee shall be limited to a reasonable amount necessary to restore the premises back to the condition it was in at the inception of the tenancy, exclusive of ordinary wear and tear." Section 1950.5e2c states, "The landlord shall not require a tenant to pay for or assert a claim against the tenant or the security for professional carpet cleaning or other professional cleaning services unless reasonably necessary to return the premises to the condition it was in at the inception of the tenancy, exclusive of ordinary wear and tear." These provisions make it clear that the landlord is only allowed to charge a tenant for what is reasonable and necessary in order to return the premises to the same state of repair and cleanliness as they were in at the inception of the tenancy, except for ordinary wear and tear, and apply regardless of whether or not a security deposit was paid at move-in. If the landlord has violated these provisions and charged you illegally, you can sue for any damages you incurred. For example, money you lost or damage to your credit because the landlord sent the matter to a collection agency. If there is damage beyond ordinary wear and tear, or the premises were left unclean, then in that situation, the landlord may charge what is necessary but must still be reasonable. I have seen situations where the landlord is charging $150 just because their contractor changed a light bulb. This would be a type of unfair business practice, and there are statutes that protect tenants from this type of egregious behavior. For example, California Business and Professions Code Section 17200 prohibits unfair, fraudulent, and illegal business practices and provides for a private right of action against businesses like landlords who engage in such behavior. Tenants have standing to sue as private persons if they have suffered injury and lost money or property due to the violation. Available remedies include restitution, which means the tenant can get a refund of overpaid amounts due to overcharges, and injunctive relief, which means the court issues an order to stop the practice. To protect yourself from landlord overcharges when you move out, you should do the following. A. Thoroughly document the condition of the premises when you move in, including taking pictures and video. B. Notify your landlord in writing of the condition of the premises and any damage or unclean areas as soon as possible after you move in. C. Keep records of all emails, voicemails, text messages, and letters exchanged between you and your landlord. D. Keep copies of all important documents pertaining to your tenancy, such as copies of any leases and lease renewal documents. E. After you give the landlord notice of your intent to move out, insist on a pre-move out inspection by the landlord or their agent if they have not already offered you one, and ask for a written post-inspection checklist that notifies you of any repair or cleaning issues before you move out. And F. Keep receipts for any repairs or cleaning you do or have done at the premises. And finally, G. Thoroughly document the condition of the premises when you move out, including by taking video and pictures of the premises. This has been a discussion of how to protect yourself from the landlord from overcharges when you move out when you have not paid a security deposit. Thank you for watching.